Good morning. My name is Ashish Thapa, and today we are working on our business and corporation law group assignment 2. So we have 4 group members in our group. So one is Ronit Manandra.
My name is Habib.
My name is Zahid Pasha Muhammad.
And today we'll be talking about the Weaver versus Harburn case, which was happened in 2014. So I'd like to start with the introduction of the company. Company directors have an obligation to make informed decisions keeping in view the best interests of the company. Their obligation includes but is not limited to proper utilization of company's funds, keeping them separate from private or personal transactions. The case of Weaver versus Harburn, which happened in 2014 WSCA 227, is one of the recent cases in Australia demonstrating the irresponsible actions of a company's director. So let's start with the introduction of the case itself. Harburn Group Australia Private Limited, is also known as the popular Harburn Group, was an Australian company provided share broking, financial and mortgage broking services. The director of Harburn Group Australia Pty was Mr. Harburn. The said company had a single shareholder named the Harburn Investments Pty Ltd, which is also known as HIPL in short. HIPL was also the trustee of Harburn Family Trust. Thus, all the important decisions and overall working of the company was managed and looked after by the sole director of the Harburn Group burden with work Harburn, Deegan and Shelley 2014. In the year 2007, Mr. Harburn was burdened with work and decided to reduce his stressful life at work by selling the Harburn Group Australia Private Limited Financial Services Business Client List. The said sale of the business client list was settled and completed on June 12, 2007. In July 2007, Mr. Harburn decided to gift his wife, Ms. Chivers, an expensive boat, and on July 19, 2007, Mr. Harburn entered into a sale contract with a boat vendor for the purchase of an expensive boat costing $385,219.35. The said amount was paid in 4 installments all through the months of July till August of 2007. With the completion of payments for the said boat, Mrs. Chivers became a registered and the sole owner of that expensive boat on August 5, 2007. In the year 2008, Mr. Harburn took another business decision and moved to a different company after subletting the premises of the Harburn Group Australia Private. Subsequently, in the year 2011, the Harburn Group Private Limited went into liquidation, finally in 2014. When the Harburn company was undergoing liquidation procedures, the appointed liquidators accused and brought an action against Mr. Harburn, the director of the Harburn Group Australia Pty, and his wife, Ms. Chivers, for unethical and unreasonable transactions made on behalf of a director of a company which unintentionally gave reasons to the court to declare and order the said transaction voidable and revert back the transaction money to the company. This claim for relief by the liquidators was done under the Section 588FF and 1317H of the Corporations Act 2001. Additionally, the liquidators of the Harburn Group Private Limited accused the director of the Harburn Group Australia Pty, Mr. Harburn, to have violated his duties as a director under Sections 181 and 182 of the Corporation Act 2001. The provisions including act in good faith for the benefit of the company and not to improperly use the position of director to gain personal benefits or advantages. The liquidators were not successful with their claims at the trial, as the court did not find Mr. Harburn to have acted unreasonably, which promoted liquidators' appeal to the Western Australian Court of Appeal, resulting in different decisions. So the duties and responsibility breached by Harburn and the results will be discussed by my colleague, Mr. Ronit Mananda.
Thank you, Ashish. The duties and the responsibilities breached by Mr. Harburn and the reasons for the breach are as follows. The Corporation Act in Australia was introduced in the year 2001, which was majorly inspired from the United Kingdom company law. Thus, in 2011, the Australian Parliament created a single legislation which governed the entire business laws and companies operating in Australia. Under the provision of Section 181(1) of the Act, every operative director of the Australian company is to exercise his powers and duties A. In good faith, keeping in view the best interest of the company, and B. To act for the proper purpose. Moreover, Section 182(1) of the Corporation Act 2001 states that a director of a company operating in Australia should not use his position in an improper manner to derive any personal advantage for himself or someone else. And B. It can be detrimental to the interests of the company. Kleiner, Clark and Adams, 2010. Thus, in the present case, the liquidation of the Harburn Group Australia Private Limited provided evidence in the form of company's account, incomes and liabilities stating that the time the expensive boat was purchased, the company's financial position was disturbed and said company was about to experience insolvency in a period of few months. The Section 588 FDA of the Corporation Act 2001, which discusses unreasonable director-related transaction, was considered to be breached by Mr. Harburn. The purchase of boat by Mr. Harburn was considered to be in violation of 588 FDA of the Corporation Act 2001 because of the following reasons. The purchase was made with company funds. The use of company funds was for a close associate of the company director. A prudent and reasonable individual would have avoided similar transaction or purchase in the current financial position of the company. Duplius, 2010. The reason presented by Mr. Harburn in his defense for himself and his wife was that the boat was a dividend to him as a director. However, his argument was duly rejected by the court as there was no evidence shown to prove that such a dividend was planned on being awarded. Another defense used by Mr. Harburn was from the accusation made by the liquidators against his wife and himself. He claimed that in view of the financial situation of the company, he was under no obligation to observe the best interests of the stakeholders or the creditors, and thus company best interest was equivalent to his own. This defense by Mr. Harburn was also rejected by the court, stating that there was lack of evidence that the sole shareholder, which Harburn Investment Private Limited, has given its permission for the said transaction. Thus, the court concluded that Mr. Harburn has breached his duties as a Harburn Group Australia Private Limited's directors, violating Section 181 and 182 of Corporation Act 2001. The decision made by the court was in light of the fact that large amount of payment used by the directors in the purchasing of boat provided no commercial justifications and was of no significant value to the Harburn Group Australia Private Limited. Moreover, the payment had been approved by the sole shareholder of the company, and the purchase proved detrimental to the financial position of the Harburn Group Australia Private Limited, making Mr. Harburn and his wife, Mrs. Shiver, the sole beneficiary of the said purpose from the company fund. Due to his improper use of resources, court concluded he was in violation of Section 181(1)(b). His breach of Section 181(1)(a) led to court's decision that a reasonable and a prudent director would have refrained from making such purchase from the company accounts when the financial position of the company was not secure enough. Moreover, Mr. Harburn has used his position as a director to benefit his wife at the expense of the company. And the court's decision and its analysis will be discussed by Habib.
The case was heard on September 10, 2014 and delivered on December 11, 2014. While it was benched by McLaurin P versus G.A. Mulfred J.A. The case was between Darren Gordon Weaver as liquidator of Harburn Group Australia Private Limited and Peter John Harburn Julie Ann Chivers. At the Court of Appeal under the jurisdiction of Supreme Court of Western Australia, the order was in favor of Mr. Harburn, and the court concluded that he had not violated any director duties or any section of Corporation Act 2001. Initially, it was stated that payments satisfied three elements of unreasonable director related to transaction at the time. The payment was made, the company was solvent, and there was no indication of suspension of company impending solvency. These factors made that matter irrelevant and why the court decided in favor of Mr. Harburn initially. The case allowed appeal. On appeal by liquidators Weaver G and Jones MB, while considering any other relevant matter, under Section 588 FDA 1C-10(6) of Corporation Act 2001, the matter was found to be highly relevant to the case considering the fact that the date of transactions, the company was insolvent. Mr. Harburn and his wife were considered guilty of violating directors' duties under Section 181 and 182 of the Corporation Act 2001. Thus, the court ordered Mr. Harburn to compensate the company by paying a sum of $385 to $19.35 and interest for breach of directing duties. Furthermore, the wife of the director of Harburn Group Australia Private Limited, Ms. Chivas, was ordered to give sum of $385 to $19.35 billion along with interest for violation of Section 588 FD of the Corporation Act 2001 for unreasonable director-related transactions, Edward at 2012. Furthermore, to these details done by my other friend.
Hi. The court is said that case considered the purchase of an expensive boat using company funds by the director, Mr. Harburn of Harburn Company Group Australia Private Limited. As a gift of very huge magnitude to his wife, Mr. Chivas, the said gift, in the eyes of law, had no valid and reasonable justification, and defense made by Mr. Harburn were deadly rejected by the court. Moreover, where was the no evidence which showed that sole shareholder of the company had consented to the said purchase of boat for which company funds were used. To this effect, the court said the commercial and financial advantage of conducting a business through the companies have consequence that those responsible of the administration of the company are prevented from the using the corporate property as if it was their own. Thus, the court concluded that individuals who are giving the responsibility of management and administration of the company cannot use the corporation funds and property that belongs to them, or the company owns them for the providing personal luxury. Thus, the final conclusion of the court on appeal was Mr. Harburn, the director of Harburn Group of Australia Private, had breached his duties and directors and violated the Section 181 and 182 of the Corporation Act 2001. Section 181 was breached by Mr. Harburn, and as he failed to exercise his duty and director for proper purpose, which would be beneficial for the company. He instead made use of company funds in an improper manner, ignoring the best interest of the company. Section 181(1) of the Corporation Act 2001 was additionally breached by Mr. Harburn at the time of purchasing the expensive boat for his wife, was aware of the weak financial position of his company, and still proceeded to purchase the same from company funds. Thus, Mr. Harburn used his position as a director improper use of his position and director, ignoring company's best interest, violating Section 181 of his Corporation Act 2001. And doing the same, he acted for his personal advantages, violating Section 182 of Corporation Act 2001. The court's decision is illustration of the Australian law regarding the violation of directors' duties in a corporation, and has been explained in the light of violation of the Act. It provides us with the knowledge that unresponsible and impractical transaction by director of the companies can comfortably occur when the company is insolvent. Moreover, those tasked with managing company affairs have no rights to property of the corporation or its trust. Lastly, a liquidator can impeach certain transactions while winding up the affairs of the company groups with a sole controlling mind. Thus, director must keep in mind that treating company assets as a own is against law in the Australian Remand 2012.
Thank you.
Thank you very much.
Thank you.